Welcome everybody to this year's Salvador Allende lecture. Let me begin by thanking the Lauterpacht Center and its director, Professor Sivakumaran, for joining with the Center of Latin American Studies in sponsoring this event and for providing the venue. I wish also to thank its administrator, Crisela de Vries, and Paula Lopez, the communications officer of the Latin American Center, for organizing it. Salvador Allende, who you can see if you could here, this was a poster printed on the day or the night of his election victory. Vencimos, I think you can understand it, a defender la victoria. It's quite an unusual, I haven't ever seen another similar depiction of Allende. He was president of Chile and died during the coup which initiated 16 and a half years of military rule and state terror under Augusto Pinochet. Allende's death and the repression perpetrated by those who seized power on that day resonated around the world as no other Latin American coup has done before or since, because they struck so many chords in many hearts in many countries. More than 50 years have passed, and still it is the name Pinochet that embodies the institutionalized violation of human rights. We are also proud here in Cambridge to have welcomed Chilean refugees in the period after the coup, and there are one or two, I think, children of Chilean refugees here in the audience, which we're very pleased to welcome. And there are quite a few people, I think, watching or listening from Chile itself. So what could be more appropriate than to invite Philippe Sands to give this year's Salvador Allende lecture? Philippe, as you all know, is a practicing lawyer, communicator, author, and what I would call ethnographer detective, who has written best-selling books about the evolution of human rights law and about crimes against humanity and their perpetrators. Highly readable books, which the author wears his intimidating erudition very lightly. He has woven the threads of high principle, the struggles to legislate, implement, and enforce international human rights law, together with the victims' own stories, sometimes even finding connections with tragic aspects of his own family history. And now, through the life of one man, Walter Rauf, he has traced a direct line from the experimental gas bans of 1942, which killed 97,000 people and prefigured the gas chambers of Auschwitz, to the fleet of 310 refrigerator vans of a frozen fish business called Pesquera Arauco, which in the 1970s transported Chilean political prisoners to the torture chambers and transported bodies away from those places to be disposed of in ways that hardly bear repeating. Although there is much else in the book, this line is the binding thread of his 38 Londres Street, title referring to the address of a torture center in the heart of Santiago, bang opposite the Catholic University, a building that had, not coincidentally, once been the headquarters of the Chilean Socialist Party. So Philippe, despite this rather somber background, on behalf of the Center of Latin American Studies and the Lauterpacht Center, with which I know you have a long association and where I believe you were a student, let me say that we are extremely honored that you have accepted the invitation to give this year's Salvador Allende lecture. Ladies and gentlemen, please welcome Philippe Sands.
Lovely introduction and also for the invitation. And yes, indeed, this building is a very special place for me because in 1984, I returned from a year in the United States to take up a research fellowship here at the new Lauterpacht Center. Well, it was the research, it was then called the Research Center for International Law, later became the Lauterpacht Center for International Law. My first job in life was in this place. And so it's incredibly lovely to be back here. Very pleased to see Sandy, and I'm very grateful to you for making this happen in this place, which is, I think I can say, the most important sort of institution I've ever been associated with, because it got me going in the life that I followed. It was only Lauterpacht who brought me here. And we had met for the first time in 1982 when I was his student. And I then became his junior colleague, and we then became colleagues, cases together, research projects together, and so on and so forth. But it was only in 2014, as I was doing research on what would become East-West Street, the first of a trilogy that will next be a quartet, of which 1300 is the third, that I came across the extraordinary coincidence in my life and Ellie Lauterpacht, who had given me my first ever job and invited me to apply for a research fellowship at St. Catherine's and at this research centre back in 1983, 84. In writing research, East-West Street, I would learn that his father was born in a small town called Zhilkiev, about 25 kilometers from the today Ukrainian city of Lviv. Lviv used to be Lvov, and before that it was Lemberg. And my grandfather was born in Lemberg in 1904, but it was only in research, following an invitation I got to deliver a lecture, not unlike this lecture, in Lviv in 2010, on my work on crimes against humanity and genocide, Impunity. But I went to Zhilkiev for the first time and learned that my great-grandmother was born on the very same street as Herschel Lauterpacht, which is East-West Street. And it was, I remember, astonishing coming up to Cambridge and going to Herschel Road, the next road along, to Ellie's wonderful house. He's sadly no longer here, nor is Kathy. Passed away just a few months ago. We were just at her memorial service at Trinity College to break to him the remarkable coincidence that has our family origins, not just to the same part of the world, not just to the same region, not just to the same village, but literally the same street. How do you possibly come up with such a coincidence? How do you possibly explain such a coincidence? And the coincidences continued to abound. After I published East-West Street, a second book followed, The Ratline. And that grew because I had come to know the son of the man, Herschel Lauterpacht and Raphael Lemkin, the originators of the concepts, respectively, of crimes against humanity and genocide. I come back to the course of this lecture. Were prosecuted at the Nuremberg trial, Frank, who had been Adolf Hitler's lawyer. And in coming to know Hans Frank's son, Nicholas, he introduced me the son of the governor of Lviv during the Nazi period. Otto Wächter was the governor, the son was Horst. And Horst one day said to me, I'd like to give you access to my mother and father's entire 10,000 family archive. Would you accept it? I said, is the Pope Catholic? Yes. And that became Ratline, sort of private lives of a popular couple. In the material that Horst Wächter so generously gave me access to, I came across a letter. That letter was dated May 1940, and it was sent to Otto Wächter, who was on the run in Rome, hiding in a Vatican-run monastery. The writer of the letter was Walter Rauff, and I didn't know the name, I have to say, or I didn't remember them when I first came across the letter. This was about 2014, 2015. And Rauff writes to Wächter, he writes to him from Damascus, Syria, where he has taken refuge. And he says to him, don't come to the Arab world. It's not a good place for us Nazis who are on the run. When prosecutors head to South America, Wächter dies in Rome in mysterious circumstances. That's the subject of the Ratline. Was it a natural death or was he poisoned? But I then got interested in this Rauff character. And the reason that I got interested in the Rauff character was that I very quickly discovered he had followed his own advice. and had made his way on the Ratline from Genoa to Ecuador, and that he had ended up living in Chile, in Punta Arenas, deep in the south of the country, as close to the Antarctic as you could possibly get. And when I discovered that Ralph had landed up in Chile, this is now 2014, 2015, something sort of tweaked in my litigator's kind of brain, because in 1998, 99, 2000, I'd been involved in the Pinochet case in the English courts. And it was just one of those sort of litigator's instincts. Could there be a connection between Pinochet and Ralph? There was no evidence for it. There was a lot on the internet. If you search, it's changed now since the book has come out, because now we have facts and we have testimony. But at the time, 2014, 2015, it was all rumor. There were newspaper articles and stuff which said that Ralph worked for the DINA, Pinochet's dreaded intelligence service. But as I dug and dug and dug, again, with a litigator's hat on, where you want evidence, not rumors, there was nothing. There were no documents, there was no testimony, there was nothing at all. And I thought, there's so much by way of rumor, I want to look more and more into this. And it took, in the end, 10 years to find out what I have found out. And of course, the first break in the story was the discovery that Ralph, who had decamped to Ecuador, had come to know some Chileans in 1956 in Quito. And the Chileans had said to him, in particular, a delightful couple, had said to him, "You're in the wrong country. You should be in our country. You should be in Chile. We like Germans and we like people like you." And 2 years later, Walter and Edith Ralph and their two boys, Walter Jr. and Alf, decamped first to Santiago and then to Punta Arenas. And he, Walter, made a new life for himself as the manager of a fishery in Punta Arenas, the Pesquera and Camellia, where he managed an operation that was charged with catching and then placing in tins large numbers of king crabs, centolla, which would then be exported to Europe and the United States very profitably. And that was his life until in December 1962, he was arrested on a warrant for his extradition to West Germany, to Hanover, indicted for genocide, murder, and crimes against humanity. His case goes to the Supreme Court of Chile, which rules by 6 votes to 1 in April 1963 that he cannot be extradited to West Germany because Chile has a 15-year statute of limitations. That statute of limitation related to his functions in 1941 and 1942, where he managed a fleet of gas vans that went around Nazi-occupied Europe, gassing people to death in their hundreds of thousands. Several hundred thousand people died in those gas vans. And that had happened in 41 and 42, and 22 years had passed, and that was more than the 15-year statute of limitations, so he could not be extradited. He goes back. Punta Arenas resumes his functions as the manager of Pesquera Camellia, met members now of the Camellia family, very interesting stories. I've also met many of the ladies, now very elderly, who worked on the king crab production line, and they have very clear memories of Walter Ralph. Following his extradition proceedings in Chile, in Santiago, they all knew the allegations of his role in the gas vans. And I would say to them, "How was it working with Herr Ralph?" And they would say, "Well, he was very correct. He was very strict." The older people at the factory didn't like the fact that he was working there, but we were young women and we were only concerned with two things. We needed a job and we needed to find a husband. So the rumors we just put to one side. And so he carries on from 63 until September the 11th, 1973. And there is the coup d'etat to which you made reference. And on the day of the coup d'etat, Walter Rauff is absolutely overjoyed. Why? Because the Chilean couple he has come to know in Quito, Ecuador, and who have brought him to Chile and who have supported him are none other than Lucia and Augusto Pinochet. His friend has now become head of the military junta and later the president of Chile. You literally could not invent it. And with that, of course, the door opens to an examination of what, if any, was his actual role in the work of the military junta. And eventually, I managed to work out what has happened. It takes a long time because those of you who know these stories will be aware that there are said to be no documents because they were destroyed by the DEA in 1977 following the murder of Allende's defense minister Orlando Letelier in Washington, D.C., murdered just off Sheridan Square by a bomb. Incidentally, there is another family coincidence for me that come all the way through the book in really quite remarkable ways. But my late father-in-law was the publisher of Orlando Letelier. And so my wife, who was 12 years old at the time, remembered Letelier coming for lunch to their apartment on the Upper West Side in New York and having lunch with them 12 days before he died. And she remembered it, she said, for two reasons. She said he was a strikingly good-looking man. A 12-year-old girl never forgets that. And the second thing was that he complimented her freckles. And a 12-year-old will never forgets something like that. So there's a point of connection there. But eventually, as David has said, and it's not the subject of the lecture, although you'll see that it plays a role in the background, I would meet a man who was detained in July 1974, Leon Gomez, and who would describe to me how personally interrogated and tortured by Walter Rauff at 38 Londres Street in July 1974. He recognized the German accent and he recognized the man's face from the photograph that had been in the newspapers at the time of his trial in 1963, because Leon Gomez said to me, as a 10-year-old boy, he loved history and he asked his father a lot of questions about who this man was. And he was later to be a history student when he was arrested in July 1974. One thing led to another, and eventually I had to go to the other side of the story and find people who were on the side in the absence of documents. I found other people who told me they had been instantly interrogated and tortured by Walter Rauff. But the real breakthrough came when I was introduced to two former DINA intelligence officers who described to me their own encounters with Walter Rauff, and one thing led to another, and it took me to a place where I would learn that on the day of the coup d'etat, September 11th, 1973, the military junta had acquired another fishery, not in Punta Arenas, but in the town of San Antonio on the Pacific coast. And that pesquera was the Pesquera Arauco, which David mentioned. And I said to the former director of the Pesquera Arauco, who himself had personally been interrogated by Walter Rauff, a scene that is absolutely identical to the central story in Ariel Dorfman's book, Death and the Nation Play, in which you recognize the person not by their face, but by their voice. It was an extraordinary moment, interviewing him and then playing him Walter Rauff's voice. I'll never forget that. But the former manager of the Pesquera Arauco said to me it was acquired on the day of the coup d'etat by the military and by Manuel Contreras, who would head Pinochet's DINA intelligence service, because the Pesquera had recently acquired a fleet of 300 refrigerated vans. And so why I asked Rob, is you wish to acquire fleet of 310 refrigerated vans. And Anatoly Zarate just looked at me and said, well, that was how they transported the prisoners, and that was how they disposed of the bodies. And the penny dropped. And that was Ralph's involvement in crimes of the Pinochet regime. So there's much in the book that is of great relevance to, obviously, the subject of Salvador Allende, including the fact that one of the principal sources, man that I spoke to very extensively in writing, a great number of people, was Juan Garces, who was an advisor to Allende and in the Moneda palace as it was being bombed on September the 11th, 1973. Juan Garces was told by Allende to leave and to keep the flame alive and share the story. Allende then became a lawyer in Spain after some time in Paris after Franco was gone, and has devoted his life to these matters. And it was he who went to a Spanish prosecutor in 1996 in April, Carlos Castrezana, not Baltasar Garzon, who, of course, is fame of the Pinochet case. He played a hugely important role. Question extradition. October 1998, the case was started by Juan Garces and then taken forward by Carlos Castrezana. And again, here the coincidences were, I think it's fair to say, beyond remarkable. I didn't know Carlos Castrezana, but Carlos Castrezana in 2021, in February, my book, The Ratline, was published in Spanish, Ruta de Escape, and I did a long interview 2 months later with El País. And my editor at Anagrama, my Spanish publisher, got in touch a little after that to say there's a Spanish prosecutor who wants to get in touch. Would you be willing to speak to him? He says he has read in El País that your next book is going to be on Pinochet Lauf. Would you like to know how the Pinochet case started? Yes, I would like to know how the Pinochet case started. We had no idea, even though we'd been involved, how it actually really started. And so during COVID in May 21, I did a long Zoom with him, and he told me how it started with a group of Chilean refugees in Madrid who had come to see me and who had noted that he was investigating the crimes of the Argentine dictatorship. Would he be willing to investigate the crimes of the Pinochet regime? He said he would. He'd look into it. He did look into it. He found that there was a legal basis. We're now April, May 1996. And he then summoned them back and said to them, there is a legal way to go forward, but the Spanish courts are incredibly conservative, and it would be better simply to open the door to getting the case up and running if you could find me a Spanish victim or a national victim. Refugee away, they come back a week or so later with 4 names, and he chooses one person to be the person who can start the entire Pinochet case. And that person is Carmelo Soria. Carmelo Soria was the head of the UN office in Santiago in the 1970s. He was abducted and disappeared on the 14th of July, 1976, and his body was found 3 days later. He had full immunities, privileges under UN law, so it was a major scandal. Castrezana chose Soria because Soria came from a very distinguished Spanish family. They were refugees from the Spanish Civil War, and Carmelo Soria's great-grandfather, Arturo Soria, was a famous urban planner who'd done a lot of construction work in the city of Madrid. There is a large avenue named after him. And Carmelo Soria's brother, older brother, Arturo, also called Arturo, was the publisher of Pablo Neruda. And so was very well known in literary circles in Spain. So Castrezana takes the case, the murder, the disappearance of Carmelo Soria, and runs with that case and goes to the courts in Valencia in July 1996, initiates the case, and that becomes the Pinochet case, which 2 years later makes its way to London following the intervention of Baltasar Garzon in circumstances describing. It was during COVID that I'd spoken to Carlos Castrezana, And I was actually staying down in Totnes, where my mother-in-law lives with my wife. My mother-in-law is also a refugee from the Spanish Civil War. Her father was a colonel in the Republican Army who fled in early 1940 and ended up at Dartington, taken in by the Elmhursts. And so there's always a sort of family base down in Totnes and Devon. And over lunch, I told her the entire story. She knew, of course, that I'd been involved in the Pinochet case 25 years earlier. By now we're 2021, so it's 23 years after the Pinochet case. And I told her she wanted to know all about the conversation with Pastrana. And at a certain point, she looks at me and says, "What was the name of the Spanish gentleman who was killed in 1976 again?" And I say, "Carmelo Soria." And she looks at me and she says, "Of course, I'd forgotten. Cousin Carmelo." In this way, 23 years after the Pinochet case entered my binge race, I discovered I had this whole family through my wife in Chile that I knew nothing about until an hour later. I was on the phone with them, and a week later I was with them in Santiago. And of course, once you've got a family connection, the stories flow much more freely and fully. So it's been an incredible journey to set the context for what this lecture is about. It is impunity. And it really is about setting the Pinochet case in its broader political, legal, and institutional context, because there's a silver line with everything. And what happened in 1973 was, of course, truly appalling, criminal, and outrageous. But as the poet-songwriter Leonard Cohen said, there's a crack in everything, and that's how the light gets in. And out of the horrors of 1973, something emerged, and what happened between 1998 and 2000. So to understand what happened in London, you have to go back to 1945 and to understand that moment which gave rise, following the end of the Second World War, of the creation of the United Nations and the negotiations of what became the statute of the International Military Tribunal at Nuremberg. 80 years have passed since that moment. And of course, we now live in a moment of transition and acute challenge: global warming, pandemics, war, economic crises, mass migration, nuclear weapons. And this has given rise to claims about whether that 1945 moment is over, whether we now live in a world without rules or in a lawless world. And what I want to do with this lecture is put those questions about international and human rights and impunity into their broader context. And I'm going to do so by taking a single issue to illustrate how rules and the values that are reflected in those rules move across time and place. And it sounds like a technical issue, but bear with me because it's important and it's interesting. And that rule is the rule that relates to immunity of a former head of state before a national court or an international court. What immunity does a former head of state have in relation to claims of violations of international law? It's an issue I've been much engaged with over the last few years. And in a sense, it is the issue that's at the beating heart of the East-West Street trilogy, a series of books, as those of you who have read will know, began in Lviv in the years after the First World War, then moved to Nuremberg in 1945, Rome in 1949, and London in the late 1990s, and then Punta Arenas in the last few years. The starting point of the story, in a sense, is 1919, the aftermath of the First World War, when the victorious powers in that conflict agreed that Germany's former ruler, Kaiser Philippe II, who has fled to the Netherlands, should be arraigned before an international tribunal. The charge is waging an illegal war, a supreme offense, as the Versailles Treaty puts it, against international morality and the sanctity of treaties. This was the first time in human history that a former head of state should be arraigned in its way and not be able to claim immunity. In the end, no tribunal was created, and Wilhelm never was actually prosecuted. The Dutch government made it clear that he was not going to be extradited to any place to be put on trial, and so he never was put on trial. But a seed was set in the Versailles Treaty of 1919. In August 1941, President Roosevelt and Prime Minister Churchill signed what's known as the Atlantic Charter, one-page set of principles that committed their two countries, the US, to a new order premised on the idea of multilateral rules that would prohibit the use of force, promote economic liberalization, and protect the rights of individuals and groups. That text informed the creation of the United Nations Charter in the spring of 1945, and then the Nuremberg Statute, which was negotiated and drafted in London in June and July 1945. A US Supreme Court Justice, Robert Jackson, was appointed by Roosevelt to serve as the chief prosecutor at Nuremberg. And he led the draft of the statute for the Nuremberg Tribunal. In June 1945, he writes a letter to President Harry Truman to set out his thinking on various issues. And one of those issues is whether any of the former leaders should be able to claim immunity before the jurisdiction of the Nuremberg Tribunal. Immunity, he tells Truman, is an obsolete doctrine. It's a relic of the doctrine of the divine right of things, and it is flatly inconsistent with the position we, the United States, take towards our own officials. Implicit in language of that text is his belief, taking it for granted, that the US Constitution provides no immunity for a former US head of state, a former US president. Jackson worried in the letter that giving immunity to any former Nazi leader or anyone who is subject to the jurisdiction of the Nuremberg Tribunal would give rise to what he called the paradox, that legal responsibility should be the least where power is the greatest. And so in August 1945, the four countries drafting Nuremberg, the British, the Americans, the French, the Soviets, adopt the Statute of the International Military Tribunal, and Article 7 provides no immunity for anybody. Gone. First time in history. That is, official conduct offers no protection, and as a former leader, even a former head of state, Karl Dönitz or Hans Frank, you will not have any to claim immunity. Both Dönitz and Frank, who is effectively the sovereign of Nazi-occupied Poland, were tried, both were convicted, and Frank lost his life. So no immunity was established as the principle before an international tribunal for the first time. That was then taken forward in the 1990s. There was a big gap between 1945 and the 1990s. Everything then changed with Rwanda and the former Yugoslavia. And it was the US really that led the world and the Clinton administration to create international tribunals for crimes committed in the former Yugoslavia and in Rwanda. And that also provided no immunity, even for a former or serving state. So, former President Slobodan Milosevic of Serbia was indicted, arrested, and tried even whilst he was serving head of state. He died before the verdict. When the Statute of the International Criminal Court was negotiated in July 1998 in Rome, it dispensed with all immunities, international crimes, over which it would have jurisdiction. For example, most recently, former President Rodrigo Duterte of the Philippines, who has recently been indicted, arrested, and is now transferred to The Hague, where he awaits trial for crimes against humanity, the murder of 41 narco traffickers, amongst others. The ICC has also issued arrest warrants for President Omar al-Bashir of Sudan and President Vladimir Putin of Russia, and Prime Minister Benjamin Netanyahu of Israel. All of that premised on the no immunity rule for present or serving heads of state. Like the United States, none of these countries, Sudan, Russia, Israel, is party to the International Criminal Court, and they reject these countries the jurisdiction of the ICC and argue that a serving head of state is entitled to immunity under general international law in relation even to international crimes. So there are still issues to be addressed, and there is still a degree of controversy in relation to a serving head of state of a country that is not a party to the statute of the International Criminal Court. By the late 1990s, what remained an issue outside of international courts was the question of immunity before national court, where it was alleged that a former head of state or government had in official conduct committed an international crime, genocide, torture, crimes against humanity, so on and so forth. And the question was a simple one. Can a former national leader ever be arrested by another country and judged by its courts for crimes that are committed elsewhere whilst that person was in office? The answer to that question is yes, or at least it has been. In recent decades, the vector of legal evolution has pulled international jurisprudence away from blanket immunity. And to my mind, as an international lawyer who works in human rights issues, that is a positive direction. The idea, of course, that the domestic criminal law should be applicable to any person, even a king or a president, before national courts is not new. In this country, in 1649, Charles I was put on trial for a wicked design to erect and uphold in himself an unlimited and tyrannical power to rule according to his will and to overthrow the rights and liberties of the people. That was the charge. He was tried, he was convicted, and he paid his head. It's an old idea. In 1764, remarkably, an Italian philosopher and jurist, Cesare de Beccaria, offered a broader rationale for the idea of universal jurisdiction, the idea that the criminal law can extend to rulers and criminal sanctions should apply globally, irrespective of where that person happens to be located. And I quote, this is from 1764. I find this very touching that even back then, people were thinking about these issues. The certainty that there is no place on earth where crimes will go unpunished may be an effective means of preventing those crimes. That's the idea of universal jurisdiction. Despite Beccaria in 1764, the reality was centuries rather different. A foreign head of state could never be subject to the jurisdiction of the courts of another country, either while in office or subsequently, in relation to official conduct. The idea being, you can't have a situation in which a head of state travels to another country and finds themselves arrested, blamed, indicted. The immunity from prosecution was total, absolute. The US Constitution, came into force in 1789, makes mention of immunity for some, but not a US president, either while in office or afterwards in combined at this point. And in 1812, in a famous case, the Schooner Exchange, the Supreme Court of the United States recognized that a serving foreign head of state has absolute immunity whilst present on American soil. It said nothing in that decision about immunity from criminal prosecution for a US president, however. Indeed, the US Supreme Court said nothing on that subject until very recently, in July 2024, which I'm going to come to. It took nearly another century and a half after the Supreme Court's 1812 ruling for the international legal regime to make a significant turn with the Nuremberg trial. And following that ruling, most of the world's nations have signed a raft of international agreements on things like genocide and torture, which oblige countries to prosecute or extradite to another country which wishes to prosecute any person who is alleged to have committed one of those crimes. So with those treaties, you know that if you travel abroad, you are at risk if you've committed one of the crimes of being subject to arrest. Those agreements differ in their approach. Some explicitly exclude the right to immunity for any person, the 1948 Convention Against Genocide, or the 1984 Convention on Torture. They pass in silence on the question of whether there's an immunity. And so we move into the 1990s. We see that one big element of the legal situation, as I said, has now become fairly clear. Former head of state enjoys no immunity when it comes to international crimes or international courts. What remains to be decided is what happens if a former head of state turns up at a national and is subject to an arrest warrant before a national court. And that is where we move to the story of Augusto Pinochet and the case of Salvador Allende. Pinochet was the commander-in-chief of Chile's armed forces, seizes power, as you know, in the coup d'etat on September 11, 1973. He heads a regime that will suspend democratic rule and due process, detain tens of thousands of people, institute a widespread regime of kidnapping, torture, and disappearance. At least 3,200 people were murdered in Chile during the Pinochet years, and tens of thousands were tortured. I've mentioned some of them who were tortured in Londres Street. To this day, the whereabouts of more than 1,300 people remain unaccounted for and unexplained. As you know from the jurisprudence of international courts and tribunals, to disappear a person is to torture the families and the next of kin who are left behind. So those are 1,300 continuing cases of torture to this day. Pinochet was well aware of the potential dangers he faced under national criminal laws, including in particular those he worried about the most, the United States. In September 76, his regime murdered Orlando Letelier with a car bomb in the Ponce Circle in the north of Washington, D.C. Within a year of that assassination, Pinochet had promulgated a very sweeping amnesty law to prevent Chile's courts from sitting in judgment on the crimes of his regime. When Pinochet left office in 1990, he was appointed senator for life, a position that gave him further protection and absolute immunity in Chile. 8 years on, in 1998, as he prepares to travel to London, he believes he has absolute immunity from the jurisdiction of any court as a former head of state who is only engaged in acts as official conduct. And bear in mind that at this point, 25 years after he took office, there has been not a single case in the Chilean courts in relation to any of the crimes committed on Chilean territory for the acts of the Pinochet regime. The only exception to that is the case in Orlando Letelier, which concerned an act of killing outside Chile. And that was to avoid anyone being extradited to the United States at the top echelons of government. So Pinochet travels to London, believing himself to be completely immune from the jurisdiction of any courts, not just the Chilean court. He's been here quite often. It's said he's on a mission to buy weaponry for the Chilean army. He has tea with Margaret Thatcher. He dines at the River Cafe. This I only discovered the other day. It's not in the book because I met Ruthie Rogers, who owns the River Cafe, and she described to me how one day in October 1998, the delegation arrived with an elderly gentleman. When he spoke Spanish, they thought it was the King of Spain. And there was a Chilean waiter in the restaurant on the River Cafe, fantastic restaurant. And the waiter recognized Augusto Pinochet as dining. She then called her husband, the famous architect, and said, what should I do? What should I do? The husband said, there's nothing you can do. You just have to carry on feeding him. Took all the whole drama and a scene. After they had paid, She tried to send money to Amnesty International. Said they did. So each of these tiny little stories gives rise to a micro account of its own. The booksellers at Hatchard's told me how he used to love going to the bookshop. He bought books you'll be interested to know about Napoleon. That was really all he read. And he watched movies, continual Star Wars. He gives an interview to New Yorker magazine to John Lee Anderson. And he tells Anderson, I want a gesture of reconciliation. I want an end to the lawsuits. Because although he's protected by his own amnesty law and other immunities, he worries about lawsuits continuing to be aired as possibilities in Chile. Mere talk of such matters, Anderson writes, agitates him greatly. An end to the lawsuits. I want an end to lawsuits. And every time he says this, he bangs on them. And the account in the New Yorker is well worth reading because it happened 1 week before he was arrested. On the evening of October the 16th, 1998, while recovering from a minor operation on his back at the London Clinic on Devonshire Place, he is arrested by Scotland Yard. The officers are acting on a warrant pursuant to the Castrosana case, which has made its way to a judge, Balthazar Garzon, in the Audiencia Nacional, who has issued an arrest warrant seeking that he be charged with genocide and torture and crimes against humanity and put on trial in the criminal courts of Madrid. The circumstances in which Garzon sent that arrest warrant are absolutely unbelievable. And in the end, it happened entirely accident, a phone call from someone at the British Embassy who alerts him that Pinochet is in London and that he is leaving the next. The only reason that phone call was made comes back to something I was talking about earlier about the importance of individuals and personal contacts, was that the person in the British Embassy, Jean Dieu, a senior diplomat who I interviewed, told me that Garzon had been very helpful to the Spaniards on a money laundering issue related to Gibraltar. And he wanted to repay the generosity of Garzon. So off his own bat, not on instructions from Robin Cook, he calls Garzon and says, I've had information, he's leaving tomorrow. At that moment, Garzon is preparing to send only a list of interrogatories to ask a series of questions to Pinochet. He tells them, and in the space of about 48 minutes, he writes out an arrest warrant and faxes it to London. If Garzon had not received that phone call from John Dieu, nothing that happened subsequently would have happened. It's the accident of life. You'll have read a lot about the conspiracies behind the whole case. That's not how it happened. It's a series of extraordinary incidents with individuals acting at a particular moment. The arrest was unprecedented and remarkable. Just out of interest, how many people here have read 38 Londres Street to get a sense? Okay, a small number. So you'll know that I've been very thorough in tracking people down. My favorite character in 38 Londres Street is the interpreter, Jean Terrace. They're simply magnificent individual who'd been an interpreter from Spanish and English for many, many months. Eventually, I found that she agreed to speak to me on the record and described to the evening of the 16th of October, 1998, and being summoned to Scotland Yard. Just very important, she was told. She was not told who it was. When she gets to Scotland, she's half British, half Chilean. She's informed because Augusto Pinochet, my word, she said. And a couple of hours later, after the arrest warrant is issued, she toddles off to the London Clinic with 4 police officers. And because Pinochet doesn't speak English, it falls to her to deliver the happy news to Mr. Pinochet. He is under arrest genocide, crimes against humanity, and it's one of those sort of totally wonderful moments where you're so excited you can't even begin to imagine what it's like to be with the person who has told Augusto Pinochet he's under arrest. First time it's ever happened in human history. And I said to Jean, what happened? What happened? What was it like? And she said, oh, marvelous. Marvelous. I told him he was under arrest. How did he react? How did he react? And she said, he looked at me with his piercing blue eyes and he said, I know the fucker who's behind this. He identified Juan Garces, and he was absolutely right. He knew exactly what was coming. Jean is a continuing character throughout the book because she's the interpreter for Scotland Yard. So every time there's an interaction between Scotland Yard, police, and Senator Pinochet, she is present to interpret. And so the stories are beyond remarkable. She sits with him as she's watching the judgments given in the House of Lords. She sees him eating dulce de leche, and she sees him weeping when the case goes against him. So she is a very, very special person. And I encourage her to write her book. In fact, there are many remarkable and special people in this whole story. For the international lawyers in the group, I think no story beats the story of the magistrate who signed the arrest warrant. Again, by unbelievable coincidence, here's my next door neighbor, Nicholas Evans, my gardens, literally a butt. And he has given an interview to no one except his next door neighbor. And he described to me how earlier in the evening, before Jean Pateras got involved, 4 police officers turned up at his house on Christchurch Hill in Hampstead. And they warned him they were coming. He said to me, Philippe, I'm not like you. I'm a magistrate. I do English criminal law. So for me, Pinochet, they turned up and they produced a draft arrest warrant. It had written on it genocide, torture, crimes against humanity. He said, I'm not like you. I don't do international law. I didn't know what any of those things were. So I crossed them all out and I wrote murder. Big problem. Courts don't have jurisdiction over the crime of murder in Chile. And that was the first of many dramas that would follow in the ensuing period. Anyway, he's arrested. The Pinochet legal team argue that the former president has absolute immunity for the jurisdiction of the English courts. They win in the division court. They argue successfully that all of the alleged acts came under the rubric of official conduct, and therefore he could not be arrested, detained, extradited, prosecuted, or anything. The court proceedings that followed before the House of Lords, in which I would become involved, were incredibly convoluted. I was originally contacted by Augusto Pinochet's legal team, and in application of the Cabranc principle, I would have done the case. I found out about it 2 weeks after he had been arrested. I was in Paris at my grandfather's funeral, and I arrived at the cemetery, told my wife with some excitement that Pinochet's lawyers had been in touch. Looked like I was going to be involved in the Pinochet case. Who for, she said. So therefore, Senator Pinochet, arguing that he has absolute immunity from the jurisdiction of the English courts. Will you do it, she said. I said, well, Cabranc principle. I believe in my rules of professional conduct. She said, I know, but as you know, I'm an American lawyer. You're an English barrister. I think the Cabranc principle is bullshit. Will you do it? I said, Cabranc principle. She said, fine. Do it, and I will divorce you tomorrow. I didn't do it. I got out of doing it. I find an exception to the Cabranc principle. And I thought that was the end of it. But 3 days later, Human Rights Watch got in touch. I went crawling back to my wife. And I had for Human Rights Watch again. So the next 2 years, the main aspect of the case was the appeal against the decision by a panel of 3 judges in the Division Court, headed by a fantastic Judge Tom Bingham, who presided over that case. And his ruling, which was done in great haste, and it was argued in a day and a half without the benefit of the full research and legal arguments, was that there was no exception in international law for international crimes. The Nuremberg precedent, he said, was completely irrelevant because that was an international court. And we are now in the English courts, and therefore a different rule apply. Bingham and the two fellow judges who settled that case wrote that they were unable to find a single case anywhere in the world in which a national court had ruled that a former head of state lost their immunity where international crimes were concerned. And that remains the case. Sufficient at that moment. Spaniards, through the Crown Prosecution Service, appealed the decision to the Lords, and eventually in March 1999, again after an incredibly convoluted episode involving a whole series of judgments from the House of Lords and the question of the relationship between one of the law lords with Amnesty International, Hoffman, the matter reached the House of Lords in 1999, and by 6-1, same vote, incidentally, as Ralph had got in his favour, the divisional court ruling was set. So Pinochet had lost his immunity. The 6 out of the 7 ruled after the 1984 Convention Against Torture had come into effect between Britain, Chile, and Spain. It was in October 1988. And it did so because that treaty obliged parties to prosecute or extradite any torturer. So the necessary implication was no immunity, although there was no immunity rule in the treaty itself. Lord Hope of Craig's Head was one of the judges in the majority, Scottish judge, concluded that any pre-existing right to immunity under international law could not survive torture on such a scale as to amount to an international crime. The ruling, premised on a world of rules and laws, had immense significance around the world. It set a precedent for the first time that would in time be followed by national courts in other countries. Henceforth, with that ruling of the House of Lords in March 1999, any former head of state who was engaged in torture or another international crime was potentially on notice that once out of office, he or she was at risk of arrest anywhere in the world. As you know, Pinochet was in the end allowed to leave Britain, ostensibly on grounds of ill health. We suspected a problem at the time. By then, I'd been retained by the government of Belgium to try to stop that from happening. We failed, and he returned to Chile. But in the research that I've done on 38 Londres Street, I have established conclusively, no one has challenged it. There was an agreement between Chile and the United Kingdom to allow Augusto Pinochet to return, essentially on the made-up charge that he was unfit to stand trial. The British extracted from that undertaking to allow him to go back to Chile that once he went to Chile, he would lose his immunity before the Chilean courts. And again, interestingly, and I've spoken to the negotiators on both sides. On the Chilean side, Christian Tolosa of the Chilean Ministry of Foreign Affairs. On the British side, none other than Jonathan Powell, who was Tony Blair's chief of staff at 10 Downing Street. Both gave me the identical account of what had happened. British wanted proof and evidence that when Pinochet returned to Chile, he would be stripped of his immunity. And so Christian Tolosa brought to the United Kingdom a document which I write about, which I have not seen, but I have spoken to both Powell and Tolosa, have seen it, and they both give the same view of what was in it, which is a document personally signed by Augusto Pinochet, authorizing one of the more notorious acts of killing late in 1973, the Caravana de la Muerte. And so I write about that in the book. The Spanish edition came out the day before the English edition. And that has caused a scandal in Chile because it is the first time there's been confirmation the Chileans do, in fact, have documents personally signed by Augusto Pinochet ordering acts of killing. And so there are now, off the back of 13 Londres Street, legal proceedings in Chile brought by lawyers on behalf of victims of the kind of muerte, gain access to that and to other documents. So the story goes on 50 years later. The Pinochet precedent is now established. It's not without its critics, but it has in effect taken hold. In 2011, just by way of example, former President George W. Bush cancelled a visit to Switzerland after Amnesty International filed a legal complaint in that country concerning the Bush administration's use of waterboarding, widely recognized, in my view correctly, to be a form of torture. And it was also the basis for Pinochet precedent very recently, just a few weeks ago, in France, called the Cassation ruling, that ex-Syrian President Bashir al-Assad could now be indicted in France for his presidential role in authorizing torture. The French court had initially thrown out existing charges against Assad, and that part of the decision got headlines, but it only did so because that dealt with those parts of the indictments which concerned Assad's crimes while he was still in office. He was still in office when the indictment was issued. Now that he's no longer in office, the indictments can be issued in relation to the Pinochet precedent. So all of this is by way of background to bring us to the present moment and to consider the context of the case as he then was when the case was proceeding in the States, former President Trump, when he went to the US Supreme Court in 2024, alleging that indictments by a US federal grand jury on various counts of conspiring to overturn the 2020 presidential elections violated his immunities under the US Constitution. That was, of course, not a case about international crimes, but the judgment is nevertheless very relevant in relation to the writ of the Pinochet precedent in the United States. I watched the case closely and followed it minutely because the issue of immunity wasn't. And in particular, as the case was making its way through the Supreme Court, I wondered whether the Supreme Court would follow the line taken by Robert Jackson 80 years earlier and offer any sort of a carve-out for international crimes. Or would it instead give a former US president some sort of immunity that was so broad it could even cover international crimes like torture or genocide or crimes against humanity, either explicitly or by necessary inference. The lower courts in the United States rejected former President Trump's arguments for a blanket immunity or any immunity. As they saw it, he had no criminal immunity as a former president for any acts, whether private or official. Though unstated, the lower court rulings left it crystal clear by extension that a former US president who tortures or commits genocide or disciplines or commits a crime against humanity or another crime under international law will not have immunity before any US court. Trump appeals that ruling to the US Supreme Court. The judgment is July 2024, Trump versus the United States. That judgment, by simply 3, overturns the lower court. The Supreme Court had never previously addressed former president's immunity from a criminal suit. Back in the Nixon era, it had once ruled on a former president's immunity from a civil suit. That's a new. There was no direct precedent on which to rely. And of course, the Constitution itself is silent on the issue of presidential immunity. Just like the Pinochet case, all 9 justices in the US Supreme Court agreed there's no immunity for private acts. So if a US president murders his gardener in a heat, there will be no immunity. that if a US president tortures his gardener as part of a process of official conduct, the situation will be very different. In relation to private acts, the Supreme Court justices ruled, like everyone else, the president is subject to prosecution in his unofficial capacity. Main judgment was written by Chief Justice John Robb. But for all official conduct, by a 6-3 majority, justices concluded the president was, unlike anyone else in the United States, protected by what is thought as a general principle of immunity. And this was because, in the view of the majority, the case had profound consequences for the separation of powers. Article 2 of the Constitution on the powers of the president was to be interpreted to protect the president's executive powers from the risk that the criminal law would be weaponized and used to constrain the exercise of those powers. The nature of presidential power, Chief Justice wrote, requires some immunity from criminal prosecution for official acts during tenure in office. But the judgment strikingly gives no real explanation or rationale for that view. What this means in practice, the authorities of justices wrote, that where the president exercises what they call core constitutional powers under Article 2 of the Constitution, let's be clear, those powers involve military action, foreign affairs, and national security, amongst others, then he will have total immunity, absolute immunity. In the view of the majority, without that absolute immunity, a president might be deterred by fear of criminal prosecution from taking what the majority described as the bold and unhesitating action which the public interest required. Well, pause there, and you can imagine that kind of rationale being used by the House of Lords in relation to the bold and unhesitating actions of the kind taken by President Pinochet in the 1970s and the 1980s. The penny's dropping. You're beginning to realize how significant this is and where this is going. Even if, in exercise of these powers, he committed genocide or torture or disappeared people or committed crimes against humanity, pause for a moment. Ex-President Duterte is facing charges of crimes against humanity for killing 41 narco traffickers in Philippines. What is the Trump administration doing in the Caribbean Sea right now? It's killing dozens and dozens of alleged narco traffickers without any form of due process. Crime against humanity, it begins to look a bit like that. But the majority seems to be saying that for actions of this kind, a former president will have absolute immunity from the jurisdiction of the US courts, criminal court. This is an incredibly far-reaching conclusion that is completely at odds with the approach taken by the House of Lords in Pinochet. The majority took a slightly different stance in relation to official conduct that lies outside core constitutional powers, where responsibility is shared with Congress. And this could include areas where Congress has legislated. For example, in relation to torture and genocide. This is unclear. Congress has shared powers to criminalize certain conduct by the president, and it has legislated in relation to torture and genocide. But, says the majority, even in such cases, a former president enjoys at least a presumptive immunity from criminal prosecution in order to enable him to act without undue caution. Immunity would only be lost if the application of a criminal prohibition to the authority and functions of the executive branch posed no dangers to the president's executive functions. Again, the source of this limitation and its application was not explained. from the decision is simply not knowable what the limits would be in relation to this more limited immunity, and its interpretation is going to have to be litigated on a case-by-case basis. Now, it might well be that if a US president were ever to be charged with international crimes, the court would find that the conduct fell outside core constitutional powers and that the president thus enjoyed only a presumptive immunity. But even if that happened, as the three dissenting justices put it, it's very hard to imagine a prosecution for official acts that poses, and I quote, no danger of intrusion on presidential authority. And that's the threshold you have to cross in order to remove the immunity of a former president. Chief Justice John Roberts has brushed away that concern of the dissenters. The limitation is needed, he writes, to avoid prosecutions of ex-presidents from becoming routine, but offered no evidence and no explanation of what the source of the concern of routine prosecutions was. It's never happened in the United States. And so the case is remanded to district courts to determine which of former President Trump's acts, subject to the federal grand jury indictment, were to be treated as unofficial conduct, and where a claim to presumptive immunity would not be sustained. Years of litigation and uncertainty would have followed. But then Donald Trump was re-elected to the presidency, and as serving president, he has absolute immunity until he leaves office again, if he leaves office. The ruling has been pretty badly received across different aspects of the political spectrum. Jack Goldsmith, who headed the US Department of Justice's Office of Legal Counsel during the Bush administration, has concluded the immunity ruling of the Supreme Court, July 2024, is a mess. He says it's got a made-up feel to it, it goes too far, it creates entirely new, and it is replete with ambiguity. And he's not alone in that critique. I went up to Edinburgh to meet with Lord Hope, former Justice of the UK Supreme Court, to get a sense from him of what his reaction was to the Supreme Court ruling. And he said to me that he found the idea that immunity was needed to allow a US president to take necessary decisions, boldly or otherwise, to be, and I use his words in quotation, absolutely ridiculous. He acknowledged the court had not explicitly addressed the issue of immunity for international crimes, but also noted that uncertainty in this regard is damaging in itself. The Supreme Court ruling left him with a lingering doubt and a worry, as he put it, that if pressed, the majority would say that its judgment applied to everything, including international crimes. The follow-on consequences of the Supreme Court's decision outside the US and for international law are not hard to imagine. For one thing, even without mentioning international law, the decision moves American domestic law on immunity in the direction of that taken by authoritarian states. The majority judgment leaves, at best, a very serious question mark when it comes to taking action against international crimes. It will make prosecutors hesitant to bring charges. It will put in place clear obstacles to success. And in effect, the mere fact of the existence of the Supreme Court ruling is going to encourage, I fear, copycat ruling in many others. The judgment may also short-circuit future American attempts to hold other former leaders to account for international crimes. What Lord Hope described to me as the foggy nature of the ruling makes it more difficult, if not impossible, for the United States to argue against immunity for former leaders charged with international crimes and facing proceedings before national or international courts. If a former US president can have immunity for these kinds of acts and for everything, as the current president of the United States would undoubtedly argue, then why shouldn't Milosevic or Bashir or Assad or Duterte or Putin or Netanyahu or anybody else? The logic of the Supreme Court ruling goes very, very far. A former head of state of another country who turns up in the US is charged with an international crime is now going to be able to assert that he should have no less immunity than that accorded to a former US president for such a crime. Highest courts in other countries, and I'm thinking Germany and Argentina, that until now have not allowed far-reaching immunities for a former head of state, could be encouraged to follow suit. If the highest American court is receptive to immunity for a former president with respect to international crimes, as this judgment seems to suggest, and as Russian law already mandates, then why wouldn't other courts of other countries follow suit? And of course, there's the double standard approach. The US president has been granted this absolute or presumptive immunity, and at the same time, the United States is abducting a president from another country, putting them on trial in its courts, and saying he has no immunity. Where does that take us? Where is it? The uncertainties generated by this ruling, I think, go very far in undermining the values that have been advanced by the United States, and in particular, the values that undermine the 1945 approach before the Nuremberg Tribunal, which stripped immunity. And it's very hard to see Chief Justice John Roberts writing the kind of letter to President Truman if he had been there in 1945 that Robert Jackson wrote. It would have been a very different path that would have followed. And of course, if Nuremberg hadn't taken that direction, the question then arises, what direction would have the House of Lords have taken in 1998? So to wrap up, I'm very happy to take in the question of the conversation. You've got a situation today where there have been extraordinary developments from 1945 through to 1998 and subsequently at both national and international courts. But the country that has probably done more than most push those developments, starting at Nuremberg in 1945, appears to have turned its back on the very idea that there should be no immunity for a former head of state who commits an international crime like Augusto Pinochet, as occurred before the House of Lords. So let me stop there, and I'm back in your hands, Mr. Chair.
The applause says it all, Philip. And we have some time, indeed, for questions. I only have one. I think you should explain to those who are not familiar with it, what was the Caravana de la Muerte?
I mean, you know what it was. It was in the weeks after the coup d'etat on September the 11th, 1973, a group of senior military officers, many of whom subsequently charged after Pinochet came back, with taking a group of basically assassins around the whole of Chile and murdering, I think it was 96, 97, senior political leaders, trade unions, leftists, and others, very senior figures around the country. That happened in October, November 1973, and it remains to this day an extraordinarily potent and controversial act. And Pinochet's public position was always that he had nothing to do with it. It was a group of military officers who went off on a frolic of their own. And so when 38 Londres Street comes out and identifies the existence of an order signed personally by Pinochet, which someone as authoritative as Jonathan Powell, the man who's basically parent of the Good Friday Agreement, hugely respected, says, yes, he gave me the document, I saw the document, I checked the document. And when Pinochet returns and is then stripped of his immunity, is indicted, never in the end faces trial, but dies in 2006 under house arrest and serially indicted for domestic and international crimes. The revelation that a document with his name on it, never having been revealed until 2025, has caused an absolute scandal in Chile, because it seems there are many documents somewhere in the system that the Chilean people have not been allowed to see.
So, yeah, so thank you very much.